Hello students, this is Divya. Welcome. I'm so glad to be back. I believe a lot of you guys are having a lot of trouble understanding this act. Well, the way we know it today, the Maharashtra Rent Control Act 2000 has a very checkered history. When it was enacted, it replaced a number of acts on the subject of rent control operating in the state of Maharashtra. There was one act which pertained to the Vidarbha region of Maharashtra. We had another act as far as the Marathwada region of Maharashtra was concerned. Largely, the Bombay Rents, Hotels and Lodging House Rates Control Act 1947 governed the issue of the relationship between a landlord and tenant in the state of Maharashtra. Now, in order to really appreciate the provisions of the Maharashtra Rent Control Act 2000, we will have to take a step backwards. We will have to go backwards in time when the original laws were enacted. So, for this reason, we will have to go all the way back to 1948. So, all the laws that Maharashtra Rent Control Act 2000 sought to repeal were enacted in 1948. What was so extraordinary about 1948? Why did we need so many laws in 1948? And this is not symptomatic of the state of Maharashtra. Almost all states in India were facing the same problem. Well, the world had just come out of a Second World War. There was a sudden influx of people from rural areas to urban city centers. There was an acute shortage of housing. Because of the terrible shortage in the housing stock available at that time, landlords got greedy. They wanted to cash in on the sudden surge in demand for real estate. They started charging exorbitant rents to all the new tenants, and they started using sharp tactics to get rid of their existing tenants. And what were these sharp tactics that they resorted to? They cut off the water supply to the tenants, they cut off the electricity supply to the tenants. We all know that in a building, a tenant may occupy an apartment, but the common areas are within the control of the landlord. So the landlords would switch off the lights in the passages, they would disable the lifts, so on and so forth. Therefore, we had all the states put in place various ordinances, various regulations in order to stop the havoc that was being perpetuated by the owners of property when the property demand had skyrocketed. That was 1948. By the time we were in 1990s, the reality had changed. In 1948, the primary concern of the legislature was to stop landlords for charging God-forsaken rent, to stop landlords from filing reckless suits for eviction of existing tenants from their properties. But by the time we were in 2000, when the new act came to be enacted, all the old buildings had aged. They had to be maintained, they had to be redeveloped, they had to be demolished and reconstructed. Therefore, we had a law in place that not only spoke about fixation of standard rent, that not only spoke about having limited grounds for eviction of tenants, but also laid emphasis on the issue of repairs and reconstruction. Now, if you ask me what is the heart and soul of the Maharashtra Rent Control Act, and I would like to emphasize the fact that the Rent Control Act is not meant for large corporations operating from fashionable districts. The Maharashtra Rent Control Act is a beneficial piece of legislation. It is meant to protect largely individuals and common people, people who cannot afford housing, people who have been living in old buildings for a very long time, and they cannot be threatened, they cannot be forced to leave these houses and rendered homeless. So what does Section 16 say? Section 16 covers the limited grounds on which a landlord can throw his tenant out of the premises and recover possession of the property. Now, if you read, and there are quite a number of grounds on which the landlord can do this. In essence, what the law has tried to do, the law has tried to ensure that a person who is really in need of the premises is protected from eviction. A rich tenant who doesn't need the premises cannot claim protection under the provisions of the Maharashtra Rent Control Act. So, let's cover the major grounds for eviction of a tenant under the provisions of the Maharashtra Rent Control Act. Firstly, change of user. Now, change of user in what I would call Rent Act jurisdiction. No matter in which state you are, no matter in which country you are, change of user is looked down upon law very seriously. So, if the property was given by the landlord for an X purpose, for example, if the property was given by the landlord to the tenant originally for the purpose of his residential use, and the tenant decides to set up a shop, and this has happened in Mumbai, especially in relation of ground floor premises. Such a tenant can be evicted by the landlord on the grounds of change of user. Now, another popular ground is erection, putting up a permanent structure in the premises, or destroying the property, or permanently rendering the property useless. Now, these grounds are common. These grounds are also covered under the Transfer of Property Act for eviction of a lessee under Section 108. Again, in all jurisdictions, all the tenants, people in occupation of premises, are bound to use the premises with reasonable care, are bound to use the premises prudently. If they act in a negligent fashion, if they do something destructive to the premises, if they damage the premises, no matter in which country you are, the landlord is well entitled to get rid of you. However, this particular ground gave birth to a lot of frivolous litigation. So in 2000, when the legislature had the opportunity of overhauling the Rent Act, it decided to incorporate certain explanations. Therefore, the legislature spelled out that closing of balconies would not amount to destruction of property. That replacing, old structures would, most of the property locked up under the Maharashtra Rent Control Act are old and excess buildings. Tenants would naturally want to have tiles done, and tiling was therefore exempted. Another important aspect of bona fide requirement of the landlord is the concept of res judicata. So a landlord may have a requirement on, say, must have had a requirement in 2001, or must not have had a requirement in 2001. So in 2001, he filed a suit against his tenant and lost the suit because the court felt that the landlord simply couldn't make out a good case for bona fide requirement. But it so happens that in 2011, the same landlord has a genuine requirement. It so happens that in 2011, the tenant has prospered. He has bought another property across the building. It so happens that the landlord's children have grown up, the landlord's children have got married, and his own children need a place need a shelter. In such a case, notwithstanding the fact that he had sued the tenant earlier in, say, around 2000 and lost the matter, the landlord, in view of the changed circumstances, in view of the fact that this time he can make out a genuine ground for bona fide requirement of the premises, he can on the same ground sue the same tenant for recovery of possession of the premises, and the doctrine of res judicata shall not come in his way. Remember, students, I keep on saying this because unless we bear in mind that the Rent Control Act is a piece of beneficial legislation, none of the provisions, if you go through the Act, none of the provisions will make sense to you. Therefore, if a property is lying fallow, by that I mean if the tenant doesn't use the property, if supposing the property is let out to the tenant for conducting business, and the tenant has decided to retire from business and he doesn't stay in Bombay. In fact, he stays in some nice place in Kodaikanal or some other state. In such a case, the landlord has the right to get back his property, and all he has to do is file a rent act eviction suit in the court, prove to the court that the property has not been used by his tenant for a continuous period of 6 months, and the court will immediately grant a decree to the landlord for granting him the possession of the property. So that is as far as eviction on the grounds of the property not being used by the tenant is concerned. But what if the tenant was in use of the property, continuously used it, and died in the premises? What happens then? Well, there are two things that all of us need to bear in mind. One is transfer of tenancies, which is really a transfer by an act of the parties. And another aspect is transmission. Now, as far as transfer of property is concerned, as I said, the Rent Act is not a profit-making scheme for tenants. If a tenant inducts a third person in the premises, or gives away even part of the premises, or creates third-party rights in the premises, then he has no right to seek protection under the Maharashtra Rent Control Act. Transfer of the whole of the premises or any part of the premises is a very good ground for the landlord to seek eviction and get back his property. However, death is not an instance of transfer of property. In case of death, the relative of the tenant staying with him at the time of his death is entitled to have the tenancy transferred in his name. So let's take a simple example. Mr. A is living in a tenanted property. He dies. However, he has 3 sons. 2 of his sons don't stay in India, and the one son who is in India, he does not stay with him. He has quit Mumbai. He has relocated in, say, some other state like Karnataka or Bangalore, where he has his own property. He has no intention of coming back to Mumbai. The 2 sons abroad too they are not citizens of India. They too don't have any intention of coming back to Bombay. In this case, the landlord can easily prove that there was no relative staying with the tenant at the time of his death, and therefore the landlord can get back the premises. However, if the same Mr. A dies and at the time of his death, one of his sons was staying with him. In that case, the rent receipt has to be, the landlord is bound to transfer the rent receipt in the name of the son who was staying with the tenant at the time of his death. So remember, students, when you draft wills, and often tenants will request you to put in a clause in a will saying that it is my wish to bequest and bequeath my tenancy rights in my property to my son A. This is an incorrect bequest. Why is it an incorrect bequest? Because a tenancy is neither transferable nor inheritable, and the only way in which anybody can succeed to the property of the tenant is under law. And what does the law say? The law says that the tenancy goes to the relative who is staying with the tenant at the time of his death. So therefore, one thing is very clear: change in tenancy is not is illegal. The Rent Act does not support change in any transfer of tenancy can lead to the eviction of the tenant. A very common trend at some time in Mumbai was, and this was especially true of commercial premises, people would enter into a partnership agreement. So A, B, C would enter into a partnership agreement, and the tenancy would be in the name of A, B and C, Messrs. A, B and C partners. Then A, B and C would execute a deed of retirement and induct a new partner, say D. Ultimately, everybody would gradually A, B and C, all three would retire, and the property would then fall in the hands of C. Now the court said these kind of shenanigans will not be tolerated. So if there is a change in tenancy and the scheme used by the tenant is that of change in partnerships, this will not hold good. The landlord will have the right to sue the tenant and get back his premises. So however, section, if you read section 26 of the Maharashtra Rent Control Act, it says one thing very clearly, that if the landlord and the tenant get together and the landlord gives his specific written consent to the transfer of tenancy, then something can be worked out. But therefore, if a tenant comes to you and asks you to draft a deed of transfer, please make sure that he has the consent, or please make sure that the landlord is a party to such a deed. And that, again, at the cost of reputation, I'm saying this, the Rent Act is a beneficial piece of legislation. The tenant is not expected to make profit out of it. So these are some of the very basic and commonly invoked grounds for and all these grounds are set out in section 16 of the Maharashtra Rent Control Act. Yet another important ground for eviction of a tenant is that of reconstruction and repairs. But invariably, reconstruction, and in both the cases, in case of repairs and reconstruction, the landlord does not get back the premises on a permanent basis. If he intends to reconstruct the property, in that case he has to bring back his tenant after the property is reconstructed. Similarly, if he is seeking to repair the property, after all it is his hazard, under law the landlord is bound to keep the building in a state of good and tenantable repairs. So if the landlord approaches the court and seeks eviction of the tenant on the basis that he intends to carry out structural repairs to the property, in that case he has to also show proof to the court that such repairs are necessary, that he will bring back the tenants once the repairs have been carried out, and he would not use the excuse of repairs to get rid of the tenant and sabotage the property. So that's far as repairs and reconstruction are concerned. But remember students, there have been a lot of changes in other laws, and by that I mean the Maharashtra Regional and Town Planning Act. Under Maharashtra Regional and Town Planning Act, a separate chapter, a separate development control regulation called DCR 33(7) has been promulgated by the state government. Now what does DCR 33(7) do? It gives incentives to both the tenant as well as the landlord to rope in a developer and have the property redeveloped, and therefore the provisions relating to reconstruction and repairs as contained in the Maharashtra Rent Control Act are not as commonly used as they used to when the act was initially enacted. Invariably, both landlords and tenants rope in a developer and take advantage of DCR 33(7) for redevelopment of the property. So now we are clear about many things. Firstly, and I am sure conceptually we know by now that the Maharashtra Rent Control Act is not meant to protect large corporates. It's not meant to protect people with multiple houses. And where are these exemptions contained? And I would like students to read section 3 of the Rent Act. Section 3 specifically states that banks, public sector undertakings, government, local authority, multinationals, companies whose paid up capital is above rupees 1 crore cannot seek protection under the Maharashtra Rent Control Act. And what does it really mean? It means, supposing I had let out the premises to a company and the company prospered. It became a multinational. Its paid up capital is above 1 crore. In that case, I as the landlord am entitled to file a rent at eviction suit against the tenant, saying that the tenant does not need the property. All I have to do is prove to the court that the paid up share capital of the tenant company is about rupees 1 crore. And it is for this reason, a lot of leave and license agreements have a specific stipulation to the effect that the tenant, that the licensee must increase the paid up capital, its paid up capital to rupees, to rupees 1 crore. It is with one of the reasons why landlords insist on such a provision or such a condition is it protects them from they get a right to evict the tenant, to evict the licensee should the licensee not hand over the property at the expiry of the license term. So as far as exemptions are concerned, please read section 3 of the Maharashtra Rent Control Act. Now, we have covered grounds of eviction. We know that the landlord can only charge standard rent and permitted increases. Now, what are these permitted increases? A lot of property in Bombay, especially South Bombay, is on collector's land. So tomorrow if the collector increases the ground rent, the landlord is entitled, within his right to pass on the burden of ground rent or property taxes or any cess that may be levied by any levy which pertains to the premises, to the building or the land, can be passed on by the landlord to his tenants. The tenants cannot complain about payment of property taxes or payment of any new levy that the government may impose. Ultimately, we need to have clarity on jurisdiction. Disputes between landlord and tenant do not go to the High Court, they do not go to the District Court. Disputes between a landlord and tenant are entertained in the Small Causes Court. So you have the Presidency and Small Causes Court in Mumbai. You have one we have one in South Bombay, in Marine Drive area. We have another one in Bandra. So these disputes, these courts also have an appellate bench. However, as far as leave and license are concerned, it's a bit of a touchy issue. As of now, there is a judgment which is in operation, which says that disputes pertaining to recovery of license fee and eviction of the licensee, even today, have to go to the cannot be these disputes. Now remember, students, if you draft a tenancy agreement or if you draft a leave and license agreement, then the arbitration clause in such cases may not be tenable, and you have to be aware of that. There is another aspect that you have to be aware of is as far as residential properties are concerned. Now there came a stage in Mumbai where landlords stopped renting out properties because they were scared of the Maharashtra Rent Control Act. So section 24 specifically states that if a licensee fails to hand over the property on the expiry of the term, then the owner, the landlord, can file an application before a competent authority. There is a special authority which has been set up for leave and license of residential property, and this competent authority immediately grants, by way of liquidated damages, twice the license fee which is agreed by the licensor and the licensee in the leave and license agreement. Now these liquidated damages can be recovered by the landlord merely by producing the leave and license agreement. However, section 55, and this is the last section that I would like to highlight, I think it is section 55. Section 55 makes it compulsory, and it is the landlord's duty to have the leave and license registered. So what does section 55 says? Section 55 says that if the landlord wants to rely upon the any agreement, he must get it registered. If such an agreement is not registered, he is liable to be put behind bars. He can be jailed for non-registration of a leave-in license agreement. But more importantly, the licensee, and especially if the licensee is an individual, he can claim to be a tenant in the premises and not a licensee. And because the document is not registered, the licensor shall not be in a position to dispute the tenancy claim of the licensee. Therefore, if you are drafting a leave-in license agreement, please ensure that the document is registered even before the tenant steps into the property.
So the
All
first
right.
question is, what is the power of a tenant if he's being evicted by a builder and landlord by majority on the basis of unfair terms?
Now, this question is too wide and vague. If you're talking about a scenario where everybody has vetoed in on, say, redevelopment of property, and that happens very often. Everybody is in for redevelopment, but one tenant tries to stall the process or resist it. And there are judgments which are applicable not only to a redevelopment of, say, an old public building, but also redevelopment of a cooperative society. In such a case, what the court has held, one person cannot stall the entire redevelopment process. So if the tenant is in minority, then I don't think he has much of a case, and there are serious consequences arising from his non-cooperation, whether which is in principle also applicable to members of a cooperative housing society. So he may not get what is promised under law, which is also the true of, say, a slum rehabilitate, what you call it, slum rehab schemes. One person cannot stall the development of, and we are talking about dilapidated buildings. Most of these public buildings are, they already have notices of being unsafe premises slapped on them. So can I
Okay,
take the next question?
the next question is, can you please explain what if the tenant of a commercial premises has paid for some repair and construction work and is now claiming rights on the property?
No, 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 no. The world over, this is not just true of Maharashtra or the Maharashtra Rent Control Act. If a tenant sets up a title which is adverse to the landlord, that itself gives the landlord to go to the small causes court and have him evicted. It's a very serious offense as far as the law is concerned. Fine, you have paid. Supposing what does the Rent Control Act itself say about repairs? Tenant repaired his part of the dangerous premises. In that case, what can he really do? He can deduct the amount from the rent payable to the landlord, and it's not that his rent that he needs to pay comes to zero. Maximum deduction that he can make is to the extent of 25%. So in installments over a period of time, he can deduct to the extent of 25% what rent he's paying to the landlord right now. But he cannot set up a title which is adverse to the landlord. He cannot say that I spent 10 lakh rupees, now I'm the owner. And if he has done that, the landlord can approach the court and have his tenancy terminated. It is in Latin it is called the equity of jus stratae, which means setting up a third party right.
Okay. What happens if the tenant is a government authority and does not vacate the premises?
Government authorities are not. I think if you can look up Section 3 of the Maharashtra Rent Control Act, it depends. For example, Central Bank has lost a lot of premises, State Bank has lost of premises. They are not protected.
Okay.
LIC has a lot of premises, they are not protected. It's the government. And if you're a tenant in a government premises, remember there's a separate act called the Public Premises Eviction Act, which is even more stringent than the Maharashtra Rent Control Act. So the government can immediately recover, possession of the premises let out by the government. So at the time when the Maharashtra Rent Control Act was passed, all these permutation and combinations were taken care of. That it cannot be that the government's hands are strengthened to such a extent and at the same time, the government cannot benefit both ways, and it's very equitable the way it functions.
Next question. What are the consequences for renting out a commercial property for residential use on the side of the landlord and vice versa?
So there are two things. If the landlord accepts sort of this, who I need to know who is asking this question, whether you're the landlord or the tenant, because letting out of property for against the use and zoning regulations has multiple consequences. One is from the perspective of the general zoning perspective, so that affects everybody, even the landlord, but it would not affect his relation vis-a-vis the tenant. But supposing you have a tenant who is letting out the property, that is incorrect. You can take the tenant, especially if especially if the landlord has not given his consent to such letting out. Now, if the tenant lets out a residential property for a commercial purpose, a commercial property for a residential purpose, your case against the tenant becomes stronger. But make sure you're not a party to this sort of the transaction.
What is the procedure for purchase of Pagri system flat in Mumbai?
See, everything, remember, the landlord has the upper hand. Firstly, maybe because I grew up in the suburbs, and I really don't understand why people spend so much money on Pagri property. Anyways, if you have to do it. In that case, first the and supposing the landlord is able to create any record in favor of the incoming tenant, that in favor of the existing tenant, that my tenant is wanting to hawk off his tenancy rights, he can very well trap his existing tenant this way and file an RAE suit. But assuming parties trust each other, okay, the landlord and the tenant has come to an understanding that, or sometimes the landlord himself comes up with the proposal. In that case, what we do, we draft something called a tenancy agreement. The tenancy agreement has three parties to it. One, the landlord, one is the incoming tenant, and one is the outgoing tenant. So the existing tenant is the outgoing tenant. So it's all documented in a one singular document, so that tomorrow the landlord is not able to rake a, everybody is protected. Because incoming tenant too needs a proof that he has entered the premises with the full consent of the landlord. The existing tenant, unless he is reimbursed or unless he gets his money, compensation, he would not hand over possession of the premises. So all these three things are documented in this one tenancy agreement, which captures who is getting how much by way of, so the usually practically how it works, the incoming tenant pays the landlord, and he pays the the outgoing tenant as well. And I think the current market rate is 1/3 goes to the landlord and 2/3 goes to the and this is legal, so it can be captured in a document. Earlier, gone are the days when Pagri was taken in black. So I think, and have it stamped and registered.
Uh, in uh, in this COVID situation, how would you get it registered?
I don't think we'll be stuck up in this COVID situation for a long time. And if you are a tenant, I believe that you must have been in the premises for a very long time. So if you have waited for, I don't know, 50 years, an entire generation, a couple of days won't hardly matter.
I would like to once again thank Plea and the Desai Foundation for giving me an opportunity to connect with students. It's always such a pleasure to connect with students. Stay happy, stay safe. Thank you very much.